Please indicate your presence. A quorum is present, Mr. President.
Good afternoon. Senate will come to order. Senators and guests in the gallery, please rise for the opening prayer to be given this afternoon by Brian Campbell, pastor of the Greater Macedonia Baptist Church, Jacksonville, sponsored by the Minority Leader, Senator Gibson.
Let us pray. Most holy and gracious God, our creator, sustainer, we thank you for allowing us to gather for this legislative session. It is our prayer that your divine presence will rest upon this place, that you will lead and direct all deliberations and discussions that will take place during this session. Let us always be mindful of those that we represent, and let us keep their best interests before us. Let us not allow divisive language and attitudes to keep us from doing the business of the people of this great state of Florida. Let the spirit of unity and oneness bind us together as we move forward in this session. Allow us to make our state a positive example for other states in this country. Allow us to show others the love still conquers over hate, and we can do more together than apart. Bless each member of this body with wisdom and knowledge needed to make this session one of the greatest sessions ever. Bless the majority and minority parties that they'll be able to come to compromise that will benefit the people of our state. We thank you for every staffer and every worker. Bless our governor and continue to bless our great state of Florida. In thy name we pray. Amen.
Amen. Senators, please remain standing for the Pledge of Allegiance to be led this afternoon by the Senate pages. The Senate pages are as follows. Aislinn Baker of Ocala, sponsored by the Senator of the 12th District, Senator Baxley. Wyatt Ballardo of Vero Beach, sponsored by the Senator of the 17th District, Senator Mayfield. Liam Fineout of Tallahassee, sponsored by the Senator of the 34th District, Senator Farmer. And Zandrick Pennywell of Midway, sponsored by the Senator of the 3rd, Senator Monfort. To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Senators, the doctor of the day is Mark Dobertine of Orange Park, sponsored by the Senator of the 5th, our Appropriations Chair, Senator Bradley. Dr. Dobertine specializes in general surgery. Welcome. Okay, let's return to the order of business, Madam Secretary. Are there reports of committees?
None on the desk, Mr. President.
Are there motions relating to committee reference?
None on the desk, Mr. President.
Are there messages from the governor and other executive communications?
None on the desk, Mr. President.
Are there messages from the House of Representatives?
None on the desk, Mr. President.
Are there matters on reconsideration?
None on the desk, Mr. President.
Thank you. Senators, before we take up the special order calendar, it's my understanding, and where's the Minority Leader Gibson? Saw her just a minute ago. Anyways, my understanding that Leader Pasadomo and Leader Gibson have agreed to roll marijuana today, as well as all of the other bills on the special order calendar to third reading for a final vote. Am I correct? Leader Gibson?
Yes, Mr. President.
Thank you. Okay, let's go to the special order calendar. Call up the first bill.
Senate Bill 2, a bill to be entitled An Act Relating to the Florida Statutes.
The Senator of the 27th District, Rules Chair Benequisto, is recognized to explain the bill.
Thank you, Mr. President. Senate Bill 2 is the Adoption Act for the Florida Statutes. It is enacted in each regular session as an essential element of the continuous statutory revision program. The bill prospectively adopts Florida Statutes 2019 as an official document and, more importantly, adopts as the official statute law of the state all statute material passed through the 2018 regular session and printed in the 2018 edition of the statutes.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Questions of the sponsor? Seeing no questions, the Senator of the 27th District, Rules Chair Benaquisto, moves that the bill be read a third time by title, having without objection received the required 2/3 vote. Please read the bill a third time.
Senate Bill 2, a bill to be entitled an act relating to the Florida statutes.
Is there debate on the bill? Seeing no debate, is there a close? Senator Benaquisto.
I'll waive my close, Mr. President.
The Secretary will unlock the board. The Senators will prepare to vote. Have all Senators voted? Lock the board and record the vote.
37 yeas and 0 nays, Mr. President.
Show the bill passes. Senator from the 27th, Rules Chair Benaquisto, or read the next bill. Come on, this is a maiden voyage up here. Read the next bill.
Senate Bill 4, a reviser's bill to be entitled an act relating to the Florida statutes.
Senator of the 27th, Rules Chair Benaquisto, you are recognized to explain the bill.
Thank you, Mr. President. Senate Bill 4 is a general reviser's bill, which deals with miscellaneous subjects of a technical, non-substantive nature, corrects grammatical, typographical, and cross-reference errors.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Seeing no questions, the Senator of the 27th, Rules Chair Benaquisto, moves that the bill be read third time by the required 2/3 vote. Seeing no objection, show the motion adopted. Read the bill a third time.
Senate Bill 4, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? Senator Benaquisto, you are recognized to close.
I'll waive my close, Mr. President.
Secretary will unlock the board and Senators will prepare to vote. Have all Senators voted? Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Senator of the 27th, Rules Chair Benaquisto.
Thank you, Mr. President. Senate Bill 6 deletes statutory provisions that have been repealed by a non-current session of the legislature, where the repeal or expiration date has now occurred, rendering the provision of no effect.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Seeing no questions, the Senator of the 27th District, Rules Chair Benaquisto, moves that the bill be read third time by the required 2/3 vote. Is there objection? Seeing no objection, show the motion adopted. Read the bill.
Senate Bill 6, a reviser's bill to be entitled an act relating to the Florida statutes. Senate Bill 6, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? Seeing no debate, Senator of the 27th waives close. The Secretary will unlock the board. The Senators will prepare to vote. All Senators voted. Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 8, a reviser's bill to be entitled an act relating to the Florida statutes.
The Senator of the 27th, Rules Chair Benaquisto, you are recognized to explain the bill.
Thank you, Mr. President. Senate Bill 8 amends and repeals sections of the statutes which grant redundant or unused rulemaking authority.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the bill? Seeing none, the Senator of the 27th, Rules Chair Benaquisto, moves that the bill be read a third time by the required 2/3 votes. Is there objection? Seeing none, show the motion adopted. Read the bill.
Senate Bill 8, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? There debate. The Senator of the 27th waives close. Secretary will unlock the board. And all members will vote. All members voted. All members voted. Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 180, a bill to be entitled an act relating to lost or abandoned personal property.
The Senator of the 22nd, Senator Stargell, you are recognized to explain the bill.
Thank you, Mr. President. SB 180, Lost or Abandoned Property, assists both law enforcement agencies and businesses in our tourism and hospitality industries by easing the burden they currently have when processing large volumes of lost or abandoned property. Currently, they have to turn their property over to law enforcement officers. It has to be held by law enforcement officers for 90 days. After 90 days, the finder may make a claim to the property. Cumbersome process. What this bill does is creates an exemption for businesses in the hospitality and tourism industry, specifically theme parks, entertainment complexes, zoos, museums, aquariums, and allows them to handle the lost and abandoned property to be held for 30 days by the owner or operator, and after the 30 days, the property can be donated to a charitable organization or disposed of.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Questions of the sponsor? Seeing no questions, the Senator of the 22nd District, Senator Stargell, moves that the bill be read a third time by the required two-thirds vote. Is there objection? Being no objection, show the motion adopted. Read the bill.
Senate Bill 180, a bill to be entitled an act relating to lost or abandoned personal property.
Is there debate? Is there debate on the bill? Seeing no debate, Senator of the 22nd, you are recognized. Waves closed. The Secretary will unlock the machine, and the Senators will prepare to vote. Have all Senators voted? All Senators voted. Madam Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Committee substitute for committee substitute for committee substitute for Senate Bill 182, a bill to be entitled an act relating to the medical use of marijuana.
Senator of the 24th, Senator Brandes, you're recognized to explain the bill.
Thank you, Mr. President. I thought I would take us back a little bit in history and kind of walk through how we got here, and then proceed to the bill and the amendment. On Amendment 2 on November 4th of 2016 was voted into law and established as part of the Florida Constitution. This section of the Constitution became effective in January of 2017. Subsequently, the legislature passed Senate Bill 8A in special session of 2017. The bill revised the Compassionate Medical Cannabis Act of 2014 and implemented the amendment. Senate Bill 8A defined the term medical use to exclude smoking. And this provision became known as the smoking ban, was challenged in the circuit court for the Second Judicial Circuit in July of 2017. But the People United for Medical Marijuana, Inc. challenged the smoking ban on 2 counts. On May 25th of 2018, the judge issued an order agreeing with the plaintiffs on both counts and ruling that the smoking ban was unconstitutional. In her order, the judge held that qualifying patients have the right to use the form of medical marijuana for treatment of their debilitating medical conditions as recommended by their certifying physicians, including the use of smokable marijuana in private places. The Department of Health appealed the ruling in the First District Court of Appeal on May of 2018, and the appeal is currently ongoing. However, in January, Governor DeSantis held a press conference in which he announced his intentions to withdraw from the appeal should the legislature not act to remove the smoking ban from the Florida statutes by mid-March of 2019. So that is what has led us to file this legislation, and we would like to move to the bar-coded amendment, and I'll explain the bar-coded amendment, which will essentially become the bill.
Read the amendment.
Bar Code 897266 by Senator Brandes, delete everything after the enacting clause and insert amendment.
Senator of the 24th, you are recognized to explain the amendment.
Thank you, Mr. President. The amendment requires submissions to submit documentation to the applicable board after certifying that a patient to smoke marijuana. This process will aid the Board of Medicine and the Board of Osteopathic Medicine in creating practice standards for smoking marijuana as required in the bill. The documentations include the routes of administration the patient has tried, if any, their effectiveness, research on the effectiveness of smoking medical cannabis, a statement that the physician's opinion that the benefits of smoking marijuana outweigh the risks. It maintains that the physician may certify a patient under the age of 18 to smoke medical cannabis only if the patient has terminal condition. The amendment specifies that the certifying physician must obtain written informed consent of the patient's parents and guardians using a form adopted by the Board of Medicine. This largely complies with the Florida right to try provisions. It allows a physician to apply to the DOH for an exception to the 2.5-ounce purchase limit and the 4-ounce possession limit for qualifying patients. Some patients with Lou Gehrig's disease and other diseases may need more, and we need to create a pathway for them outside this current pathway, and so that's what this provision allows. It allows for the board to research the consortium, to fund research through a teaching nursing home on the effectiveness of medical cannabis on age-related conditions, and if the teaching it does not require MMTCs to sell pre-rolled marijuana cigarettes, but if an MMTC does sell such cigarettes, it may not use hemp tobacco wrappings. The MMTC may sell paper wrappers, but it may not sell pipes or paper wrappers made from hemp or tobacco. It specifies that nothing impairs the ability of any party to restrict smoking or vaping marijuana on his or her private property. It requires a consortium for medical marijuana clinical outcomes research to be established in a state university designated by the Board of Governors. It removes and repeals the proviso provision that we had in the previous version of the bill that passed out of appropriations. And it adds a $1.5 million in recurring GR to the Board of Governors and the consortium for the purposes of research. That is the amendment.
Are there amendments to the amendment?
On the desk, Mr. President.
Read the first amendment.
Order Code 733576 by Senator Brandes. Delete lines 14 through 15 and insert amendment.
Senator of the 24th, Senator Brandes, you're recognized.
Thank you, Mr. President. This amendment clarifies that the authorization to purchase delivery devices from vendors other than the MMTCs applies only to the delivery of devices for medical use of marijuana by smoking.
Are there questions of the amendment sponsor? Questions of the amendment sponsor? Being none, is there debate on the amendment? Debate on the amendment. Senator Brandes, you recognize close on the amendment.
I'll waive.
Waives close. Senator Brandes, having waived close on the amendment to the amendment, all those in favor signify by saying yea. Yea. Opposed, nay. Show the amendment adopted. Read the next amendment.
Order Code 264942 by Senator Brandes. Delete line 181 and insert amendment.
Senator Brandes, you recognize to explain the amendment.
Thank you, Mr. President. This increases the 35-day supply that a physician may certify to a patient to receive at a single office visit from 1 to 6. So they may have 6 35 days periods before they have to come back to their physician.
Are there questions of the amendment sponsor? Questions of the amendment sponsor? Is there debate on the amendment? Debate on the amendment. The amendment sponsor having waived his close. All those in favor of adopting the amendment signify by saying yea. Opposed, nay. Show the amendment adopted. Read the next amendment.
Order Code 219464 by Senator Roussan. Delete lines 289 and 290 and insert amendment.
Senator Roussan is excused this afternoon, so the senator from the 33rd, Senator Thurston, you are recognized to present the amendment.
Thank you, Mr. President. This amendment simply adds oversight from the Department of Agriculture and Consumer Services to the effectiveness of an applicant's medical marijuana diversity plan, included in their application for initial licensure and licensure renewal of MMTCs. It also directs the Department of Agriculture and Consumer Services to submit an annual report on the effectiveness of MMTC's diversity plans to the Governor, the Senate President, and the House Speaker. The Department of Agriculture and Consumer Services supports this initiative. This is an important provision we are hearing because we're having major concerns about the Department of Health just checking the box and not having any follow-up on the diversity plans of the MMTC's owners. Across the state of Florida, African Americans are 4 times more likely to be arrested for possession of marijuana. From a county-wide perspective, several counties have experienced even higher numbers. According to the Tampa Bay Times in Pinellas, Hillsborough, African Americans are 6 times more likely to be arrested. Gainesville Sun, cited by the ACLU, found that 6.6 times more likely. Additionally, Sarasota County has the largest disparity in the state, where African Americans are 10 times more likely to be arrested for marijuana possession. Therefore, we find the need to have this compliance, to make sure it's not just a check in the box and we don't get back to it. But to be sure, Senators, there's a need for serious discussion not only on the compliance, but there's a need for a discussion of the MMT licensing procedure as a whole. Vertical integration is simply not working for Floridians, and it's certainly not working for my community. I've spoken with the bill sponsor about this very important legislation that we have here today, and because of our discussion, and we're looking to make some improvements and actually have that serious discussion about vertical integration, I'm going to be withdrawing this amendment at this time, but I thank you for hearing us on this issue. Thank you.
Show the amendment withdrawn without objection. Before we read the next amendment, Senator of the 1st, Senator Broxson, understand you have an introduction.
Mr. President, it's my great honor to welcome to the chamber in the East Gallery the Mayor of Milton, Heather Lindsay.
Welcome. Welcome to the Florida Senate. Read the next amendment.
Bar Code 320934 by Senator Brandis, delete lines 761 through 767 and insert amendment.
Senator of the 24th, Senator Brandis, you're recognized.
Thank you, Mr. President. This simply clarifies that the Coalition Board must collaborate with, in addition to being authorized to provide funds to, a teaching nursing home in conjunction with research on the effects of marijuana on age-based conditions. That's the amendment.
Are there questions of the sponsor? Questions of the amendment sponsor? Is there debate on the amendment? Debate on the amendment. The amendment sponsor, Senator Brandis of the 24th, waves his close. All those in favor of adopting the amendment signify by saying yea. Opposed, nay. Show the amendment adopted. Show the amendment adopted. Read the next amendment.
Late filed Bar Code 944380 by Senator Farmer, between lines 288 and 289, insert amendment.
Senator Farmer of the 34th. This is a late filed amendment. Requires 2/3. Show that introduced without objection. Senator Farmer, you are recognized to explain the amendment.
Thank you, Mr. President. This amendment is designed to facilitate access to this new legal medicinal treatment. And it is designed to encourage our veterans who are suffering from things like PTSD and pain syndromes related to their service to our country. Anything we can do to alleviate the reliance on opioid medication, I think we all would agree is good policy. And so what this amendment would do would be provide free medical marijuana access cards to our veterans so that they don't have to incur that fee. And it just makes this potential optional treatment more readily available to them and potentially encourages them maybe to not go on opioids, at least not at the first step. And of course, all of these decisions would be made through the advice of a physician and the patient consulting together. And I believe this is an important issue we should take up. I've discussed it with the sponsor. I think he is very understanding and sympathetic to the concept. But we also understand that we're on a small time frame here to comply with the governor's request on this issue, and we're dealing with our friends across the rotunda on some sensitive issues here. So in the interest of advancing this legislation and not bogging it down, I'll be withdrawing this amendment, but I do look forward to offering it again and perhaps including it in your licensure bill as we move forward. Thank you, Mr. President.
Show the amendment withdrawn without objection. Read the next amendment.
Late filed barcode 299090 by Senator Farmer. Before line 5, insert amendment.
Late file amendment requires 2/3 for introduction. Show it introduced without objection. Senator of the 34th. Senator Farmer, you recognize to explain the amendment.
Thank you, Mr. President. And this amendment, as well as the next one that I'll be talking about, again, sort of the theme here is this is a new concept for a lot of folks, that marijuana is now a legitimate medical option. It's medical treatment. It's Tylenol. It's any other kind of medicine you could be prescribed or that you could buy over the counter. But we want to make sure that people aren't discriminated against for resorting to or choosing to implement this legal medical treatment. And so what this amendment would do would limit an employer's ability to terminate an employee who tests positive for marijuana in a drug test, who is a licensed card holder. Now, the amendment would provide that employers can terminate an employee if they're using marijuana on the job and it affects their job performance. But simply because they're obtaining relief from pain or whatever other condition they have at night in the privacy of their own home, and they are a legal card holder, if they are subject to a random drug screen, they shouldn't be fired because they test positive. And so, again, for the reasons I stated earlier, to ensure that we roll this bill to third reading, I'll withdraw the amendment at this time, but look forward to having this discussion again when we do the licensure bill. Thank you, Mr. President.
Show the amendment withdrawn without objection. Read the next amendment.
Late filed barcode 876992 by Senator Farmer. Between lines 667 and 668, insert amendment.
Late file amendment requires 2/3 for introduction. Show it introduced without objection. Senator of the 34th, Senator Farmer, you recognized.
Thank you once again, Mr. President. And again, looking to eliminate any discriminatory effects of people utilizing this new legal medical treatment. I was shocked to learn that some patients who are on transplant lists for kidney or other organs are being dropped from the list simply because they are shown as a licensed card holder under the database. It's one thing if maybe you're talking about a lung transfer and smoking of an item would impact the viability of that organ, but patients should not be discriminated against who need a kidney or some other transplant simply because, again, they are exercising a legal medical option. And so, again, this is an important issue to make sure that people who exercise this option are not discriminated against, especially here where their very life may be at stake. For the reasons stated earlier, Mr. President, I will again withdraw this amendment, but again, look forward to working with sponsor down the road on this important issue. Thank you.
Show the amendment withdrawn without objection. Read the next amendment.
No further amendments to the amendment, Mr. President.
Senators, we are back on the delete everything amendment by Senator Brandis. Are there questions of the sponsor? Questions of the sponsor. Senator of the 37th, Senator Rodriguez, you recognized for a question.
Mr. President, thank you. This applies to the amendment and then obviously the bill prior to and as amended. And we probably can't avoid litigation, but one of the areas where it seems that we're out of step with the Constitution I wanted to ask you about, and that is with respect to the use of the different standard applied to patients when they have terminal versus debilitating conditions. Could you explain a little bit why that is being done?
Senator Brandis, you're recognized.
And you're speaking specifically to those individuals under the age of 18, correct?
Senator Rodriguez, you're recognized.
Thank you. I am not, my understanding, so there are, with respect to some of the steps that patients need to go to, there are different standards for persons with terminal conditions, that are non-terminal, I guess, debilitating conditions that are non-terminal versus those with terminal. But then there are even more steps when we're talking about minors, as I'm reading the bill. I mean, I'm not going to go through them. I'm just trying to zero in on the fact that, not to belabor the point, but obviously a terminal condition is one that's likely to lead to death. And that's very different from a debilitating condition which is one that relates to a significant interference with the ability to go through daily life. And the constitutional amendment and the Constitution mention some of those debilitating conditions like PTSD, glaucoma, metaphysician, but I don't think those are terminal. And so it gives us some context in addition to saying that this medicine.
Senator Rodriguez,
yeah,
you might want to save that for debate.
Right. No, but I'm trying to crystallize the questions. I'm not trying to go through the different steps in there. I'm just trying to get at the difference between terminal and debilitating and why there are more hoops if the condition is not terminal.
Senator Brandes.
Thank you, Mr. President. As it relates to terminal and it really deals with individuals under the age of 18. As we're trying to hone in and say they have access to all the other forms of medical cannabis, but under 18 they have to have 2 physicians and they must be shown to be in a terminal condition. And one of those physicians has to be a board-certified pediatrician. So that's really where we focus in on the word terminal condition as it relates to those individuals under the age of 18.
Senator Rodriguez, you're recognized.
Thank you. So my question is just why do we make that distinction for minors?
Senator Brandes.
So in my discussions with physicians and my discussions with the House and a variety of other sources, we are looking at and making sure that individuals who use medical cannabis under the age of 18, they currently have to have 2 physicians. That's what the current law is. And we allow them access to vaping. We allow them access to tinctures, oils, all of those they have access to today. Specifically, as we're trying to address it, is just smoking, right? Just smoking medical cannabis and whole flower smoking. And so we thought that there was, the physicians I talked to did not believe that they would ever provide that. And then in our negotiations with the House, we settled on this, which is essentially the right to try language that Florida had adopted a few years ago. So we think that they may potentially have been covered under the right to try law as it stands. We thought that the appropriate way to handle that was to put for those individuals under the age of 18 to specifically spell out those provisions that we include in right to try. The only major change we have here is that it requires a board-certified pediatrician to be one of the physicians that certify it.
Further questions? Further questions? Senator Harrell, you're recognized for a question.
Thank you, Mr. President. I so appreciate the opportunity. I have several questions. The first of all deals with the ability, the 35-day supply in the form of smoking and the extension of that to being able to receive 6 individual 35-day supply allotments, basically. And currently in statute, if that a patient can, for regular marijuana, if they ask for an additional extension of that, you can appeal to the Board of Health, the Department of Health, to get an extension for more than the supply that's allowed in statute. Would that apply also, the same language apply also to smoking marijuana?
Senator Brandes.
If I understand the question correctly, you're asking about the 6 times that they can go, the 6 35-day periods. And what we do, that just conforms to what the standard is for all the other types of marijuana today. So if you go to a physician, you have essentially 6 35-day periods that you can go before you have to go back to the physician. That was what the standard was for all other forms of medical cannabis. We thought it was appropriate, if we're just adding full flower, to make that the standard for this as well. So that stays the standard across the board. We don't want to make it more expensive and have any individuals have to go back to their physician once a month, essentially, in order to get full flower cannabis.
Senator Harrell, you're recognized.
Thank you, Mr. President. In a way of follow-up of that, if the individual feels that they need more than that 6-month supply, basically, they can appeal to the Department of Health. And if the Department of Health does not answer that appeal within 14 days, it's automatically approved. So would that extend then to the smoking of pot, and could you also get that for, say, 2 years? Could that extension extend for 2 years or 3 years?
Senator Brandes.
Thank you. And to my knowledge, it's not an extension to go back to the physician. It's extension on amounts. So we allow individuals to possess up to 2.5 ounces of full flower, but for some individuals, they may use more than that for their medical condition, specifically if they have, Lou Gehrig's disease or other type of conditions that would qualify, and their physician then would have a process to go to the Department of Health and seek more medical cannabis. This is exactly the same process that we do in all of the other areas of cannabis. So if it's an oil or if it's a vapor, they can go and apply to those physicians. So this just lays out that same process.
Senator Harrell, you're recognized.
Thank you very much. And on line 659 through 665, it discusses smoking marijuana in a nursing home. And can you clarify for me what a nursing home would have to do if they chose not to allow that in their nursing home?
Senator Brandes.
Thank you. There's this interesting subject to talk about, because if they take federal funds, they may be federally prohibited from allowing smoking cannabis. But our bill simply allows it at the state level if the policy of the nursing home is to allow it. So they must adopt a policy, and if they adopt that policy, if they're in a nursing home, they're in a hospice, or they're in an ALF, then they can. It allows those facilities to allow individuals to utilize medical cannabis on their facilities.
Senator Harrell, you're recognized.
Thank you very much, Mr. President. A large number of our individuals in nursing homes are paid for under Medicaid. Would that then require every nursing home that accepts Medicaid to establish a policy to allow it if they chose to, and would that put them in jeopardy?
Senator Brandes.
Thank you, Mr. President. Nothing requires that a nursing home, an ALF, or a hospice adopt a policy. They can adopt a policy to ban medical cannabis. They can adopt a policy to allow medical cannabis. But it's really to make sure that the state doesn't prohibit them from adopting a policy as it relates to medical cannabis on their property.
Senator Harrell.
And do you have it? Thank you very much, Mr. President. Would that put them in danger if they adopted a policy to allow smoking of marijuana in their facility? Would that put them in danger of losing federal funds through Medicaid?
Senator Brandes.
Thank you, Senator Harrell. As you know, I'm not an attorney, I'm a Christian. And so I can't answer those types of a question that specifically is of a legal nature like that. I would simply state that that really it's a legal question that they need to work through with their attorneys as they're adopting a policy of this nature.
Senator Harrell, you're recognized.
Yes, and I'd like a little more information on how we're setting up the new consortium. It had previously been, there had been a coalition, and it was housed in in Moffitt Cancer Center. Can you give me some additional information on exactly what board is going to determine what universities are to participate in the consortium, and also where the funds, the $1.5 million that we're going to allow for research to go into, to what university would that go?
Senator Brandes, recognized.
Thank you, Mr. President. It will all go to the Board of Governors, and the Board of Governors will establish the universities that can participate in the consortium, and the Board of Governors will allocate the funds.
Senator Harrell, you're recognized.
As we go forward with the research, which I think is absolutely essential, are we going to require that part of that research also gather information as to what the conditions are that were required for smoking medical marijuana? Are we going to make sure we know that an individual is smoking? What conditions were necessary to precipitate the use of smoking medical marijuana, and also the outcomes that are that we can see 6 months, 9 months, a year later? Are they going to be tracking that as well?
Senator Brandes.
Thank you, Mr. President. If you go to page 6 of the amendment, line 137 starts with what a physician has to provide to the department. And part of what they have to provide is the research around this. So every time they're writing a recommendation, they need to provide the research and the reasoning for why they're doing this. We do this today with all other conditions as it relates to medical cannabis. So if they fall into that category, they have to provide the research that goes along with that. We're also saying now that if they have to do that if it's smoking as well.
Senator Harrell, you're recognized.
Yes, to follow up on that, are you going to be requiring that they also report improvements or deterioration in condition as a result of smoking marijuana?
Senator Brandes.
Thank you. Again, they're going to go back every essentially 210 days. They're going to go back to the physicians, and the physician has to re-up that. And so I would imagine that will be in the new report that they issue every time they go back to the physician.
Senator Harrell, you're recognized.
Outcomes usually are measured very differently than a diagnosis code. And normally, presumably, they would be doing a diagnosis code as part of the form that they fill out for this. Is there any specific requirement that they report outcomes? Was there improvement? Was there deterioration in the specific condition for which they were ordered the medical marijuana?
Senator Brandes.
Thank you, Mr. President. We make them provide a number of things. We make them provide a list of other routes of administrations, if any, that the certified by a qualified physician that the patient has tried, the length of time the patient has used such routes of administration, an assessment of the effectiveness of those routes of administration in treating the qualified patient's qualified condition, any research documenting the effectiveness of smoking as a route of administration to treat similarly situated patients. We have a statement signed by the physician and showing that their opinion that the benefits of smoking medical cannabis continue to outweigh the risks for a qualified patient. That's what we require.
Senator Harrell. Okay, before we move further in questions to the senator from the 18th, Senator Cruz, I'm going to recognize the senator from the 31st, Senator Berman. You have a recognition, I understand.
Thank you, Mr. Speaker. Oh, Mr. President, excuse me. I would like to recognize the mayor of Delray Beach, Shelley Petrolia, who is from my town, and welcome.
Welcome to the Florida Senate. Okay, further in questions. The senator from the 18th, Senator Cruz, you're recognized.
Thank you, Mr. President, and Senator Brandes, thank you for getting this bill in proper posture and order. You know that I voted for it once before, and I intend to vote for it again, but I do have questions, and it speaks to the appropriation, because as I looked at the appropriations, I noticed that there's $1.5 million in recurring general revenue to the Board of Governors to implement the consortium. And then I saw another $705,000 in recurring trust fund money to implement the requirements of the Act. And my question to you is that I'm sure that we are collecting fees on all of this implementation. And my question is, why are we assigning this a recurring general revenue allocation when it should be coming out of the fees?
Senator Brandes.
Thank you, Mr. President. And as you pointed out, there is some money coming out of the fees, some money coming from the trust fund. But I think the $1.5 million in general revenue and recurring shows Florida's commitment to research. That's really what this is all about. It's all about, we're focused on research, and I think it shows that Florida's willing to invest through the Board of Governors, through our great state universities in research. I think it actually highlights the commitment that Florida's willing to make, that all Floridians may benefit by additional research, and that's why we're taking it out of GR.
Senator Cruz, you're recognized.
New question,
yes.
Mr. President. I had a constituent that came in today, and so I feel compelled to ask this question. And the question was on the prescription limit for the medical marijuana at 2.5 ounces every 35 days. Their concern was that that was an excessive amount, and I think they said that it was more than Cheech and Chong could smoke in 35 days. So could you speak to the amount that is allocated?
Senator Brandes.
Thank you, Mr. President. And if you look around the country, this puts us basically in the middle of where the other states are as it relates to medical cannabis. So I think as we looked at the research, as we've talked to individuals, we've talked to different physicians that relate to this, there are some conditions that will require much less. There are some conditions that may require more, and we wanted to make sure that we provided a pathway for individuals who need more. But I've talked to people just this month who today in Florida use about 4 ounces a month because of, and are legally allowed to use 4 ounces a month because they use it, they take that whole flour and they grind it up and use it in oils and use it in edibles for their conditions. But specifically people with ALS and other debilitating conditions may be high users. And so we thought that the amount should be appropriate, but also have it for about 90% of patients. We think, 2.5 ounces will be enough. But there's also a pathway for more.
Senator Cruz, you're recognized.
Thank you, Mr. President. So am I right to assume that the doctor will make the determination on the ounces that will be prescribed monthly?
Senator Brandes.
Doctor will make a recommendation for the amount. That's correct.
Further questions? Senator of the 33rd, Senator Thurston, you're recognized.
Thank you, Mr. President, and I thank you for bringing this legislation. As an attorney and a Christian, I had a few questions for you. I noticed that a lot of the provisions have to do with minors under the age of 18. Do we know what percentage of the patients will be minors or are minors now in the numbers?
Senator Brandes.
I don't have any of the current numbers about how many minors are using. I'm sure we can ask the Department of Health to provide those.
And just lastly, I know you were answering Senator from the 37 questions about terminal and different conditions. And I was just wondering, if a patient is not terminal, there's no minor again, there's no way for that patient to ever have the use of smokable marijuana. Is that what we're saying?
Senator Brandes.
Under this bill, that's correct. The provisions here are they have to have a terminal diagnosis and they have to have 2 physicians, one being a board-certified pediatrician.
Further questions? Senator of the 31st, Senator Berman.
Thank you, Mr. President. Senator Brandes, thank you for bringing this bill. And I just have a question about when you can get your refills on the 35-day supply. I'm concerned because I know with other pharmaceuticals, you can often get them before the end so that you're not in a position where the 36th day comes and you don't have your supply. And also when you go on a vacation, often you're obviously it would have to be in the state of Florida, but you can get a vacation refill. So is there anything contemplated in this bill that you can get it prior to the end of the 35th day, or you have to wait to the 35th day?
Senator Brandes.
Thank you, Mr. President. No, you would have to wait to the end of the 35th day. Now, we allow you to possess up to 4 ounces. So if you had some left over from a previous month, you could continue to possess those and get to the max amount of 2.5 ounces. We wanted to make sure we left enough space in there for individuals. But we expect people to be using this, and we think that ability provides enough access for individuals.
Further questions? Further questions? President Lee from the 20th District, you're recognized for a question.
Thank you, Mr. President. And I have only a rudimentary understanding of this subject matter. I have not been involved in any of it, Senator Brandes, so I apologize for what may seem to be some pretty elementary questions here. But I think at a minimum, Mr. President, it's important to get them on the record, maybe not even for this bill, but for what lies ahead. There's been reference to the Constitution and how we're in conflict with the Constitution. I think the courts have found we're in conflict with the Constitution. I saw on page 2, one small reference in Section 6 to making provisions in public places for smoking medical marijuana. Is there any other, we've gotten into a stage where we, much like we see every election cycle for candidates, we sign petitions to go to the polls that says one thing, and then we run a campaign that says another,
And the public thinks they voted for the campaign, when in fact what they really voted for was the petition. So can you help, for the record, the public understand how this bill meshes with the petition itself, why this bill is necessary pursuant to the petition that was signed by the voters and therefore what was placed in the Constitution?
Senator Brandis.
Thank you, Mr. President. And Senator Lee, before let me look for my notes here, but understand, don't worry about the elementary nature of this, of your questions, because most people haven't studied medical, or most people in this room haven't studied medical cannabis since college. So what the judge said, and that's who's actually reviewed the constitutional petition, she said that qualifying patients have the right to use the form of medical marijuana for treatment of their debilitating medical conditions as recommended by their certified physicians, including the use of smokable marijuana in private places. And so I think as we look, the judge went through the petition. She went as the challenge, and that was her order.
President Lee.
Okay. As it relates to liability, I didn't, this is considered medicine now because we put it in statute. The FDA doesn't consider it medicine. And yet physicians are going to be empowered with the ability to write prescriptions for medical marijuana, smokable marijuana. Are there any limitations of liability for physicians who are now put in the position to have to issue prescriptions for something that hasn't been approved by the FDA, and therefore they don't have the cover of the approval process, that's rigorous approval process that's typically been put in place for drugs in America?
Senator Brandis.
Thank you, Mr. President. They're covered by the Constitution. So the Constitution provided liability protection for physicians who recommended medical cannabis.
President Lee.
That's good. So what is that? Is that a simple answer or is it a complicated answer?
Senator Brandis.
Well, I don't have the constitutional language here specifically in front of me, but I believe that the Constitution provides civil liability protection for physicians who in good faith recommend medical cannabis.
President Lee.
Thank you, Mr. President. In terms of
Senator Brandis, further
Thank
response.
You. Our crack staff has come into my aid, and the current statute says a physician shall not be subject to criminal or civil liability or sanctions under Florida law solely for issuing a physician certification with reasonable care to a person diagnosed with a debilitating medical condition in compliance with this section. So we have statutory protections for those physicians as well.
President Lee.
Thank you, Senator Brandis. That's very helpful. In terms of Medicaid, there's been some discussion about it. There's no requirement that this be provided under Medicaid. Is that correct?
Senator Brandis.
Thank you, Mr. President. No, there's no requirement for any health care companies to provide this. In fact, this is largely a cash business.
President Lee.
Thank you, Mr. President. How about in terms of, has anyone contemplated the effects that smokable marijuana might have on the Medicaid program as people develop other symptoms and conditions relating to smoking or the use of cannabis for that matter, and may well end up with a condition that lands them in the Medicaid program? Has there been any conversation about that?
Senator Brandis.
Thank you, Mr. President. There has not been any conversation about that. The upside is we have $1.5 million every year that we're going to be doing on research to continue to look at that, and also looking at with medical nursing homes and the aging population. We expect a lot of research to come out of that as well.
President Lee.
What I hope, Mr. President, will be one final question. In terms of liability for the consumer of medical marijuana, driving under the influence, our drug-free workplace or employer liability issues for people that may come to work in some form of impairment. How is all of that going to work? Is there anybody thought through that yet?
Senator Brandes.
Thank you, Mr. President. Well, part of that is employer-specific. Obviously, if they're a drug-free workplace, they would have to potentially have an exception to the policy for someone who has medical cannabis. This bill provides individuals to prohibit medical cannabis or smoking of medical cannabis on their private property. So they would be able to have people be prohibited. And then it also says that you can't smoke in a public place. So you can only smoke in a private place. We would think of that as someone's home, someone's medical setting, if that's allowed by their medical setting.
President Lee.
Thank you, Mr. President. I guess one final question. I honestly don't anticipate, although you've done wonderfully with these questions, I don't really anticipate everyone have thought through all of the intended and unintended consequences of this brand new public policy. But in a circumstance where someone is operating heavy machinery in a construction setting and you know, they haven't smoked on premises, but they're clearly under the influence, they shouldn't be on heavy machinery, and they're at work, is their employer going to have any liability associated with that, since they have no control over whether or not the employee is able to use this new drug?
Senator Brandes.
Thank you, Mr. President. Again, it comes back to the specific policy of the employer. So if they have a drug-free workforce policy, if they do drug testing, it really is dependent upon the policy of each employer and, frankly, their insurance company as to the liability and whether they're conforming to the provisions of that policy.
President Lee.
I'm sorry. So maybe this is the best way to ask it. So who's in control? If I'm the employer and I want to have a policy that says people can't be impaired during their work hours, do I have control over that policy, or does the right to medical marijuana under this prescription program drive? What's in control?
Senator Brandes.
So I think you have control of the policies of employment for your employees and how they're, you know, what they're allowed to do, whether they're allowed to handle heavy machinery or other types of devices. So ultimately, I believe it would be an employer policy as it relates to this, and you would be in control of that policy.
Further questions? Further questions? Senator of the 22nd, Senator Stargell, you're recognized.
Thank you, Mr. President. And my question is very simple, Senator Brandes. We're here today for this discussion. You briefly touched on the lawsuit that happened, and then the governor decided he wasn't going to appeal. So let's say that that's the case, and the governor, and we don't pass anything today, and this bill were to fail. What would be the state of regulation around the smokable marijuana as the courts have stated?
Senator Brandes.
Thank you, Mr. President. I think it would go back to current law, and that we would allow MMTCs to sell full flower with essentially no caps on limits to what they could sell. So it would go back to that standard, and there would be some question of whether they could smoke in a public place. That would be also a question that would be debated. There would be some question of whether people could not allow them to smoke on their private properties. I think that would be a question. If this was not to pass, obviously there would be no research component if this was not to pass, and the court's court's finding would stand.
Senator Stargell.
Thank you, Mr. President. And so all of those decisions, and I think even whether a person could smoke it under 18, all of that, all of those things then, with the absence of us passing any legislation, would be decided through our court system via a variety of multiple lawsuits? Is that what would happen?
Senator Brandes.
No, I don't think they would be decided. They may be decided that way, but largely unless somebody was impacted, they wouldn't be decided. That would be the law. Anyone under the 18 would be allowed to smoke medical cannabis if this was not to pass. But in any of the other provisions that you discussed would be allowed unless a city or some other municipality took some authority on that.
Senator of the 29th, Senator Rader, you're recognized.
Thank you, Mr. President, and thank you, the Senator from the 24th, for all the work you've done on this in short order. I got a few questions, and I think you've spoken a little bit about patients under age 18. The bill limits smoking medical marijuana for minors up to a patient under age 18 who must be diagnosed with a terminal condition, and a qualified physician must certify that smoking is the most effective means of administration for the patient. Why do you need the concurrence from a board-certified pediatrician also needed?
Senator Brandes.
Thank you, Mr. President. The Florida Right to Try Act has 2 physicians to sign off on experimental medication. And so we use that framework and recognizing that they were under 18 and thinking about who we would want to be that second physician to be. We thought that these individuals would be seeing somebody who was a pediatrician likely, and that pediatrician should be of the highest caliber, and the board certification is certainly pediatricians of the highest caliber, or at least the best way for us to be able to provide that. So that's why we set that standard. It really does rhyme with the Florida Right to Try Act.
Senator Rader.
Thank you, Mr. President, and thank you, Senator. Do you think that might add more financial burdens on families who are dealing with their child's terminal condition by having to get that second opinion?
Senator Brandes.
Thank you, Mr. President. I think if we're talking about 10 or 12-year-olds smoking medical cannabis at the end of their life, these individuals are seeing quite a few physicians today anyway. We would imagine that they're already seeing a a pediatrician as well, and I don't believe that will add financial burden for those individuals, because clearly they're seeing a lot of physicians at that point of their life.
Senator Rader.
Thank you, Mr. President. We've heard from patients and advocates that after paying out of pocket for the doctor's visit to get qualified and paying for the medical marijuana ID cards, some patients can't afford to buy the medication. Does anything in this bill address the cost of the medication or financial assistance for patients?
Senator Brandes.
Nothing in this bill addresses that issue, but my hope is that as we address the regulatory structure and follow on bills, that we will begin to look at that. I think, as you heard testimony the other day, that we've got licenses selling for $80 million to out-of-state companies that are from California or Colorado or Canada or Massachusetts, and they're recouping that cost of that license on the backs of patients. And I think we can address the licensure structure, and that will help drive down cost over time.
Senator Rader, you're recognized.
Thank you, Mr. President. Have you thought about doing any kind of late file amendment on that issue that you just brought up? You had a whole bunch of other amendments. Would you take up a late file amendment on third reading on that issue?
Senator Brandes.
I think that's probably something that needs a deeper discussion and to be vetted through the entire process. If we're going to change the entire licensing structure, probably would not be appropriate for a third reading amendment.
Senator Rader, you recognized.
Thank you, Mr. President. Senator from the 24th District, I was the alternating chair for JAPSI for over the last couple of years, and we had a really big issue with the Office of Medical Marijuana Use, how they ignored letters from our committee and our committee staff. Is there anything in this bill that addresses the issues that were in that vein, that the executive branch just completely disregarded what we, the legislature, asked them to do?
Senator Brandes, let's keep it to questions.
Thank you, Mr. President. No, nothing in this bill specifically addresses that. I'm encouraged, though, that we have a new governor, a new administration, a new vision for